But let's be clear, what the government wants the parliament to do today, in the last 2 weeks of this year, is to rush through a manifestly, apparently unconstitutional bill to deny millions of Australians in the future their ability to sue big corporations and rich and powerful individuals. There are serious concerns that have been raised about the constitutionality by the Law Council of Australia, by QCs who practice in this area, and indeed by Justin Gleeson SC, the former Solicitor General of the Commonwealth, one of the nation's leading constitutional lawyers, has given advice publicly to the committee about the number of ways in which this bill is almost certainly unconstitutional. That means, in plain English, the parliament doesn't even have the power to pass these laws. Yet the government, pig-headed, wants to rush them through in the last 2 weeks of parliament as a favour to their corporate mates. This is a dog of a bill, Deputy Speaker. It would be difficult to overstate how truly bad it is, both in its aims to deny justice in the courts to everyday Australians harmed and their ability to fight big corporations. Also in its execution, it's not even executed competently. I mean, they want to help their big corporate mates, but they can't even do it properly. It's also appalling in its dishonesty and the spin from the government. Now, the stated objective, which we agree with, is to protect the interests of plaintiffs, that's victims, in class actions. Its real objective is to protect the interests of powerful defendants by making it harder for people to bring class actions. What are class actions? In plain English, they're lawsuits where everyday Australians can come together to take on big corporations and powerful defendants who've done wrong. Think robo-debt, where the government was found to have acted illegally. But this is a testament to the government's monumental incompetence that they failed to achieve either objective, to help victims or to protect their mates. I'll quote from one of the submitters, that the government is seeking to present this reform as a consumer protection measure is Orwellian gaslighting. Further highlighting the idiocy of this legislation is that it is opposed by leading class action defendant lawyers from Herbert Smith Freehills. So the people who represent the big end of town are saying this is bad law. Now, superficially it sounds nice. The government's professing concern to get more money out of the judgments to go to victims. You know, those nasty old lawyers charging too much and the greedy litigation funders we heard in the previous unhinged rant. So what are litigation funders? We heard they were bottom feeders. They were people who make money from human misery. They're private businesses that fund the cost of big lawsuits. That's what they do. They assess the risks and they offer to fund litigation. If the case is successful, they get a percentage return. If they lose, they pay all the legal costs, possibly the other side's costs, and victims pay nothing. That's what they do. The government pretends to be concerned that litigation funders take too much. In some instances, yes. But the question is, the policy questions, you've got two competing objectives. How do we maximise return to victims and drive down legal costs and litigation costs and funding costs and maximise access to justice? You've got to try and do those together. The answer clearly is competition. That's what the ALRC has said, that's what every sensible expert has said, that's what the evidence and experience shows. If you get competition right, you drive down funding costs, and that's what we've seen in the last few years. New entrants come to Australia, they're all evil and overseas, according to the previous speaker. They're businesses prepared to lend and take risk. They come to Australia, and we've seen the average costs of funding already decrease in the last few years from about 30% down to sort of close to 20%. Competition's working. So what's the government's response? Well, a rebuttable presumption, as they say, to cap returns to litigation funders and lawyers at 30%. The sting in that is that includes the legal fees. It means that victims pursuing justice would have their legal fees effectively capped by the government. Victims couldn't hire the best QCs. They'd be down the road looking for cheap lawyers like Dennis Denuto, although poor Dennis Denuto actually did do a reasonable job in the movie. But big corporations, their lawyers, they'd have no limit on the amount they could spend on their lawyers. They could have the top QCs, they could bleed the victims dry by playing games in the court, and that's exactly what would happen. That's what all the lawyers told us is what would happen. It's what any basic sense of economic principles tell you, that that's what would happen, and it won't be a fair fight. The evidence we heard in the committee was absolutely clear, Deputy Speaker. This 70-30 notional formula would drive up litigation costs. It would discourage plaintiffs from settling, providing perverse incentives for litigation to just roll on and roll on. It'd make the law, I quote, worse for everyone, said the Law Council of Australia, John Emery QC. It would raise the risk for funders. There'd be fewer dollars around for many meritorious claims where people have been harmed, and the costs for all claims are likely to be higher. That's the evidence which the committee received all day, with a couple of exceptions. The new rules about sign-ups would also lead, this is astounding, would lead, everyone admitted, there would be an increase in the number of lawsuits lodged because there'd be multiple closed class actions, so big companies that the government's trying to help would actually have them subjected to more lawsuits. That's why even the top-end-of-town lawyers who help the big corporations have said this is a stupid idea. They can't even help their mates properly. Facepalm emoji, if we could insert that into Hansard. So let's be clear. To deal with the costs, this government, the free marketeers over here, are choosing regulation, not competition. Soviet-style price caps, as one of the submitters said. So much for market forces. The hypocrisy is astounding, coming from this mob of free enterprise. The rush process, though, is also a clue, and even the Financial Review, you know, that left-wing socialist communist rag, published very clearly an article yesterday analysing the whole thing, saying this is rushed, it should not proceed. The members of the public were given 1 week, less than 1 week actually, it was 4 working days when you take out the public holiday in most of the country. They were given 4 working days to comment on the exposure draft. The government ignored the feedback and introduced the bill, pretty much the same. A government-controlled committee had 3 weeks. The public had 7 days to put in their submissions. There was 1 public hearing, 2 business days to get back to us, and the only people who didn't get back to us were the government's own departments who didn't meet the timelines. If only the government felt the same sense of urgency about, I don't know, responding to the Banking Royal Commission, the Federal ICAC. Whatever happened to the Corruption Commission? Anyone? No Corruption Commission, over 3 years, 1,000 days, no urgency about that. And yet this bill, to deny access to justice to millions of Australians, is suddenly the most urgent thing on the agenda, and we've got to shove it through before the election. The inquiry showed it is a deeply flawed bill in every respect. The overwhelming evidence, even from the people who support some of the propositions, is it's badly drafted. And the report, frankly, is pathetic. I mean, it's probably, to be fair, the best you can do in a few days. I feel for the Secretariat, but Labor members had less than 24 hours to respond to the report and deal with it on this most complex of issues. The government struggled to find anyone to submit to support the bill. The Australian Industry Group loyally turned up. I suppose they had to, and said some stuff, but they couldn't really engage in the detail. The Business Council hadn't put in a submission when they appeared, couldn't engage in the detail. The poor AICD didn't put in a submission. They seemed almost embarrassed to be there. To their credit, they put in a supplementary submission after the hearing, then reversing their position on some aspects, which was good. The funniest moment, though, the moment of levity, was the Rule of Law Association. They had no submission, but they turned up. I don't know, the government invited them. They had no ability to engage in the bill. It was kind of the vibe of the thing, you know. The presenter had no expertise. He was unwilling or unable to engage in any substantive discussion. I asked whether I could join the Rule of Law Institute because I like the rule of law, and they said no. It's not a membership organisation. They wouldn't tell us who funded it, but they love to write op-eds in right-wing newspapers. They were later accused of misstatements by other submitters who listened to their evidence, but the government, in their wisdom, are relying on their evidence in this report to back in this bill. We also had Stuart Clark QC, who paraded himself around on paper as the former president of the Law Council and an adjunct professor at Macquarie Uni. He didn't turn up, which was a pity. We had some good questions for him, like, did you plagiarise your evidence? Because mysteriously the evidence that he put in was identical to the submission from the United States Chamber of Commerce on the exposure draft. Just a Deirdre Chambers-style coincidence, no doubt. It was sad he didn't appear, although last time he appeared I don't think he had a great experience. I think he had to register as an agent of foreign influence in the end, just to be prudent. But look, Deputy Speaker, I want to make some very serious remarks on the constitutionality of the bill. There are serious doubts whether we can even pass this bill. Let that sink in. The Law Council, the former Solicitor-General of the Commonwealth, gave compelling evidence that this bill is not constitutional. Justin Gleeson SC said, There are serious concerns about whether the corporations' power in the Constitution or the referral powers to the Commonwealth support the provisions we're now being asked to vote on, whether the provisions wouldn't amount to an inconsistency with state class action provisions so as to override them pursuant to section 109 of the Constitution, potential issues arising in respect of overriding the power of state courts or directing state legislatures. Despite this, the explanatory memorandum from these geniuses over there, the government, doesn't mention the constitutionality at all, not a word. We spent an hour or more grilling the Attorney-General's Department. Nothing. They could not rebut one single proposition from the former Solicitor-General. Nothing. Absolutely nothing. Now, I can't go into what we discussed at the committee, but let's just say I'm confident that there's members of the government that share these concerns, and this is not the end of the constitutionality questions. As everyone from the legal profession said clearly, if this bill goes through, what it will do is tie up the profession in years of litigation in the High Court to pull this legislation to bits, because everyone knows that large swathes of it are not constitutional. Now, in the real world, this all sounds very esoteric, but in the real world, what it means is if these laws are passed, numerous cases where victims in Australia have suffered harm and have a meritorious case will not proceed in the future. Now, this is best illustrated by examples of recent cases that could not or would not have proceeded had these laws been in place. I'll give you 5. The Domino's Pizza case, a class action by delivery drivers and in-store workers about underpayment of their wages, could not have proceeded under these laws. The stolen wages case for Indigenous Australians, the reason it couldn't have proceeded under this regime, it's one of the most complex of cases. It's expensive to fight. And you can't just go out to remote Aboriginal Australia and sign up defendants all over the country. You need the open class action system to get justice for vulnerable people. The big banks, like Westpac, they overcharged their life insurance customers allegedly, but that class action couldn't proceed under these rules. A case against the Commonwealth Defence for contamination of army land in Queensland. Robo-debt, there's a long list.